Welcome back to the Conduct Detrimental Podcast. This is your co-host Dan Worley. I'm joined by my co-host Dan Wallach. Dan, what's happening?
Deflategate revisited. That's what's happening. Our favorite sports topic of the year. We've been asked to weigh in on what are the top sports law issues of 2016. I think this might be the top sports law issue in our careers. And, the man who was at the center of Deflategate, right in the heart of Boston, doing so much great reporting, is going to be our guest today. And Bob is definitely one of our favorites. And I'm looking forward to revisiting Deflategate and maybe providing some closure on the topic, although there will never be closure. I mean, to this day, when I tweet anything that has any kind of a connection to Deflategate, I get more of a reaction. Even months after the controversy ended, I get more of a reaction to that than anything else. And this is like months after the fact.
That's crazy.
Yeah. I'm sure Michelle McGurk is still penning another amicus brief or something like that. I don't think it's ever going to be over for her.
She's given up. Can you believe that? She's absolutely given up. That is so unlike her.
All right, before we get too far ahead of ourselves, we really need to introduce our guest. Bob McGovern from the Boston Herald. Bob did just a fantastic job reporting on Deflategate over the last 18 months or so, and we're really excited to have him. When Dan and I sat down for the first time and talked about this podcast, we talked about some of the episodes that we wanted to do right away, and Deflategate was one of the first ones to come to mind, and Bob was the first name that came to mind in that discussion as well. So we're really happy to have you. Bob, I know you've been recovering from an illness this week. How are you feeling?
Very good, very good. Now that it's snowing here in Boston, so I got healthy just in time to shovel my car out and come into the office today.
Perfect. Glad we're putting you to work.
Yeah, we've got a little bit of a chill here in Miami, too. It's gone down to the mid-70s, if you can believe that.
Got long sleeves today, Dan.
We feel bad for you. We do. So I guess, a good place to start, I think, Bob, is, you have a legal background. You're a lawyer. You've been covering legal stories for a while now. I mean, just talk to us about what it was like to cover this legal story in Boston with, the crazed Boston fans surrounding the story and all the hype that happened, from the beginning and then through all the legal proceedings.
I mean, it was definitely one of the most interesting stories I've covered in my career. People were really, really into it. Not just Patriots fans, but kind of some of the angrier fan bases who don't like the Patriots that much were super into it as well. So Twitter turned into an interesting place for me. But, one thing that occurred very quickly was I realized that it's going to be people don't have the same basis of knowledge of the law as maybe some people that we may think they do. I mean, people don't know the difference between civil and criminal court, and for all they know, Judge Susan Garsh, who presided over Aaron Hernandez, does the same thing that Judge Berman does. So, starting with that in mind, it was very challenging, but also kind of fun to put things in layman's terms. I mean, obviously, you guys helped me out a lot with that.
Yeah, Bob, did you find it difficult to maintain a sense of objectivity? I mean, first of all, you're a reporter, you're a lawyer, you analyze, issues, legal issues, based on your knowledge of the law, but your audience is very much, one-sided in how they view the controversy, largely coming in against the National Football League and siding with Tom Brady. Did you find it difficult to maintain a sense of balance without necessarily irritating a large portion of your fan base? Because, you take a look at Ben Volen from the Boston, Globe. He was pillared, for trying at least at the beginning to look at things from both sides of the equation. So what kind of a struggle was that for you being in Boston?
And I'm a Giants fan. So
oh, good. Me too.
I have no allegiance to the Patriots. So this would sort of be like if I, went to Philadelphia and had to cover the Eagles for somebody. So the team, the player, it didn't really matter that much to me. To me, it was easy to kind of come down on the side of the Patriots and Tom Brady because initially, as I read through things, I was putting myself in the position of, imagine if this was Eli Manning and the Giants. Imagine if what I considered to be fundamentally an unfair process occurred to my team. So at the beginning, I was kind of just, waiting for all the facts to come down. But then when I saw the Wells report, and then as things kind of transpired quickly from there, I think, and maybe this is just my opinion, but I think objectively, it looked like things were some unfair things were happening to the Patriots. And so that's kind of how I came down a lot of my reporting. And when there were missteps that you both noticed as well on the side of Brady and the union's attorneys, I said as much, and I told the readers that, and if they didn't like it, that's what I'm there for, to tell them what's going on.
Yeah, I mean, for me, it was the first window into the unfairness of the proceeding wasn't necessarily the Wells report, but when the arbitration transcript and all the arbitration exhibits were unearthed and the veneer was pulled away from those documents in a court-filed document, that to me was the first telltale sign that, wait a second, this was just outrageous. The trial or the arbitration appeal seemed like it was a railroad, and Brady's Brady's rights. If it wasn't clear from the Wells report, it was certainly clear from the arbitration transcript, and I found that to be a very shocking document in terms of how one-sided the NFL's approach was in terms of how they handled evidentiary issues. I don't think Brady got the benefit of anything on any evidentiary ruling, any witness issue. The procedural unfairness became underscored just simply by reading that transcript.
Yeah, and frankly, it's when I saw the words general awareness for the first time. Mm-hmm. That's when something clicked in my head that something was amiss, because to me, general awareness of a scheme to maybe deflate football seemed so it didn't seem like they came down hard on anything. They paid Ted Wells a lot of money to do an extensive investigation. And then when I saw general awareness of something that may or may not have happened, and then that leading to a penalty just days later, that's when that's when it clicked to me that maybe, not to pick a side, but to maybe really look critically at what the NFL is attempting to do here.
Right. I think one thing to me, even before all of that, or I guess in the process of that, but if you just think about it and say, let's give the NFL the benefit of the doubt. Let's say that Brady did everything that they're accusing him of. Is it still worthy of a 4-game suspension? And I think the answer to that from the start was clearly no. There's no parallel case that no player that's been suspended for anything similar. There's no real reason in the CBA for him to do so other than this sort of overarching power. And so that's what really triggered it for me as far as, wow, is the NFL really out to get their star player? And, kind of looking back on it through that lens, I mean, do you guys think that in hindsight that the NFL would do this all over again, or they would just sort of do a Deflategate 2 and ignore it?
Well, they're ignoring it now. We have Deflategate 2.
That's what I mean. If they had
wrapped
revisionist history, would they go back and treat Deflategate 1 like they treated Deflategate 2? Well,
Bob, we'll let Bob answer, first. I have my own views on it, but go ahead.
I mean, I think that they've won everything they need to win right now. If this thing was just a vessel for them to give Roger Goodell unfettered power through the court system, they got what they need to get. If this was the vessel to get there, then it's not necessary to bring Deflategate 2 down. It's not necessary to cause this PR nightmare all over again. They've already got what they wanted. As far as I can tell, he has pretty much unchecked power. We're going to see what happens to my Giants with this walkie-talkie scandal. But, there doesn't seem to be a need to cause another hyphen gate all over again if you've pretty much solidified yourself as the judge, jury, and hesitate to use the word, but I guess executioner in these cases.
Well, I think go ahead, Dan.
I'm good. Go ahead.
Yeah, I think Bob's right. The NFL now has what they want. I don't know if the vessel or the court outcome was what was desired at the outset. This was just a disciplinary proceeding, but now now having won that, they have the additional layer of a Second Circuit Court of Appeals opinion. And I think the NFL can pick and choose their battles, knowing that they will likely discourage any litigation going forward. I mean, what is the likelihood of another case ending up before the U.S. Court of Appeals for the Second Circuit? So they've accomplished several victories here. They've eliminated the District of Minnesota as a forum going forward. That was a favored forum of the Players Association in trying to battle any of the NFL's disciplinary decisions. That's now gone forever, unless we're talking about a player for the Minnesota Vikings. And one thing that doesn't get enough attention is the NFL's conduct in how they chose the New York forum. You know, we've practiced, you know, we've been litigators, we've practiced in the courts. Usually you get an issuance of a decision and a period of time following which a party has a right to decide whether to take it to court or for an appeal. The NFL never released the decision. They issued the decision virtually simultaneously with when they filed suit for declaratory judgment in the Southern District of New York. That is unprecedented in the annals of NFL litigation. But they won. They were never called on the carpet for that kind of ham-handed procedural shenanigans. So in the long run, they've got a New York forum as probably the preferred forum. They have a Second Circuit decision. I think this will have a channeling effect in discouraging any future litigation. And I'm skeptical that we will ultimately see a Deflategate 2 ever rise to that level.
Yeah, it was interesting. Yeah. Go ahead, Bob.
Yeah, and I hesitate to think that there's a lot of conspiracy theories among the Patriots fans that Goodell has it out for Brady himself for whatever reason, for the Spygate or the past, or certain things that have, that the Patriots are always one step ahead of the law, I guess. I don't buy that, and I think that you're right. I think that this, when it turned into litigation, it turned into a power play for the NFL, which is why they ran to federal court to claim jurisdiction. And the funny thing is about that, as soon as Judge Berman sided with Brady, Twitter blew up that he was in the bag for the Patriots, that he was somehow some sort of Patriots fan and was seen at he was seen at some gala with the Patriots owner. I mean, it turned into a mess really quickly. And, I guess that was all part of the fun of covering this thing.
Yeah, and that was kind of the ironic part, is the NFL fought so hard to keep the case in New York, and then they ultimately lost in front of Judge Berman. It just goes to show you that even, the Paul Clement of the world, who's the NFL's lawyer, who's arguably, one of the top lawyers in the country, can make that kind of miscalculation. And ultimately they won in the appeals court, but it just goes to show you that every legal decision like that is really a balance and not necessarily a certainty. So,
yeah, I mean, my takeaway on these things, the difference between winning and losing is often a very thin veneer. Whether you win or lose often depends on the judge you draw. And in the NFLPA's case and Brady's case, they got a great judge. On appeal, there were 12 or so potential judges in the pool for the Second Circuit. The league drew 2 out of 3 good judges. You shuffle the deck again and pick another group of 3 judges. Maybe Brady wins the appeal. That's the oddity about the law, the courts, and precedent. That the same facts, the same legal issues, the same application of law to fact could lead to different results depending on judicial assignments. And with the Second Circuit, we had a split decision. We had a majority of 2 and a dissenting opinion. You remove Chin from the process, or you remove I forget the name of the other judge, but you swap in a different judge, we might be looking at a completely different result months later. And it's somewhat stunning that years of precedent going forward, and the effect of that precedent will turn on the identity of one particular judge being part of the panel. And walking into that oral argument that day, it seemed as if Brady was winning it 5 minutes in, and then just the roof caved in. And I think Denny Chin was particularly overly fascinated with the factual elements of the case rather than the law. And for me, I just shake my head sometimes. I've won some, I've lost some, and sometimes it's a matter of which judge you draw.
Yeah, I remember at halftime, so to speak, of oral arguments that we were all sitting together in that courtroom to peel back the curtain, and you turned around and said, "I think Brady's got this," and we were all in agreement. We were all like, "Yep, that's about right." It looks like the judges just skewered the NFL, and there's no way that they can come back from this. But then, things took a turn pretty quickly after that.
I wasn't in the courtroom that day, and it was interesting because that was my impression too. I had talked to a bunch of people going in, I had made my own opinions. I think everyone was under the opinion that Brady was the heavy favorite at that point. And then I talked with people immediately coming out of the courtroom who were in the courtroom. Dan, I believe you were one of them, and it seemed like everyone had seen a ghost. It was just a total 180. It's now Brady's the complete underdog. I can't even imagine him winning after, what they just went through. Can you talk a little bit about, what you guys saw as far as the lawyers there and how Jeffrey Kessler, Brady's lawyer, reacted to some of the judges' questions?
I mean, I don't know if Attorney Kessler was necessarily prepared for the amount of questioning around Brady's cell phone. I hesitate to use the word prepared here because obviously Attorney Kessler is a great attorney. He's prepared for mostly everything, but they really harped on that. And when, there was question number 7 about Brady's cell phone, whether the cell phone was a deciding factor, whether you could punish him for the cell phone alone, it started to look like everybody but Judge was pretty much leaning toward siding with the NFL.
I mean, it's difficult to blame Kessler for not being – he was prepared, but the expectation of the oral argument was that the issues would focus on appellate issues, arbitrators' discretion, and in a way deciding whether the cell phone destruction enough could have justified a 4-game suspension. I guess that was within the area of discussion. He was prepared. The question is, we could all Monday morning quarterback the situation, but the Players Association couldn't have switched lead generals before oral argument. Let's not forget he won. He won before the district court, and looking over the history of the Southern District of New York with arbitration decisions being vacated, the rate of vacator for labor arbitrations was less than 5%. And he was one of the outliers, and we're talking about the top sports litigator in the country. How would it have looked if Brady had chosen to go with a different lawyer and then lost? I think the outcome would have remained the same no matter who the lead horse was. And it's Paul Clement has the Midas touch. He's undefeated representing the National Football League, but I don't think this is a situation of one side out-lawyering the other side. I think these judges had their minds made up. At least 2 out of 3 of them did. Maybe 3 out of 3 of them did. And nothing that took place during the oral argument, in my opinion, changed their minds. It would have been 2-1 if Bob and I had argued the cases and switched sides and argued the cases. That's how strongly I feel about it.
It may have been 3-0 if I was arguing it, actually. But listen, I don't want anything I say to make it seem like I don't think Attorney Kessler's a great attorney. I was just myself struck by the questioning, and I think others in the room were as well, including Attorney Kessler. I think most of us went into it, as you both said, thinking that Brady had the lead. After being behind for so long during this process, all of a sudden he was the front runner, and then to kind of see the way there was all of a sudden about face. I mean, the air came out of the room for those that thought that Brady was going to win the day and possibly set some damaging precedent in the NFL's backyard.
Yeah, that's a great thing about oral argument. There are never any mysteries. We debated during the Judge Berman, oversight of the case. What was he playing poker? Was he just sort of being cagey, trying to get the lawyers to settle the case? No such mystery with appellate oral arguments. You 9 times out of 10, you walk out of that room and you have a pretty good idea who won the appeal. So that's why the air got sucked out of the room, because we just knew it. We knew it. They weren't going to, sort of tip their hand like that so obviously, and then, just, come out with a completely 180 degree different outcome. That's the brilliance of appellate oral argument. I don't think I've ever missed a call on which side was going to win, especially when I'm not involved. I've sat in, dozens of oral arguments not involving me, and my batting average for those are 1,000. It's pretty evident because everything is distilled to 15 or 20 minutes, and they get right to the point and the points that matter to them. And, we knew that there was no sense in waiting for the written decision. By the way, the written decision came out barely 1 month later. So, their minds were pretty clearly made up.
Yeah, it's a good point. And I found it just so bizarre that they really focused on the facts, especially the cell phone, like you guys mentioned during the argument. That's usually not how it goes. Those weren't the stated issues in the briefs, but obviously, when the judges see something that catches their eye that maybe hasn't been developed as much by the parties as they want, they're going to dig into that in oral argument. And I think that's what happened there. Bob, you mentioned earlier our favorite intervener in this case, Michelle McGuirk. Am I saying her name right? Do we know how to say her name?
I just call her Michelle McGuirk because at UMass, the football stadium is McGuirk Alumni Stadium, and it's spelled the exact same way. So I'm just basing it on my prior knowledge.
Okay, we'll go with that. We'll go with McGuirk. So for those who don't know, McGuirk managed to wiggle her way into this case as an intervener at the district court level. She basically tried to appeal part of an opinion, which is just kind of wild to do. And then when the case was appealed, she managed to appeal her decision as well, and sort of was tacked on to the appeal. So she was part of the court docket, part of the proceedings, although the court basically ignored her throughout the way.
We were too. We were also part of the proceedings. Remember, we were named as respondents. Bob McGovern as well. Michelle McGuirk at some point became particularly piqued by the fact that you and I would often quote from her court filings and take a screenshot of the image of one of her court filings and put it out there on Twitter, and she sought the equivalent of an injunction to prevent us from using Pacer to discuss what happened in the case. And she named me, she named you, she named Bob, she named Michael McCann of all people, and the entire Brady Deflategate legal squadron as respondents. I was tempted to file a response just so that I can insert myself into the case for time immemorial.
Yeah, again, the Second Circuit ignored that opinion, but it was our brief, I guess you would call it a claim to fame in Deflategate, where we were actually part of the proceedings. And interestingly, the same thing happened in the Derrick Rose case, too, a few months later. So, going back to just McGuirk in general, I mean, Bob, she was kind of this mysterious creature. We never really knew who she was. Someone apparently spotted her at the Second Circuit oral arguments, but that was about it. Did you ever, try to reach out to her, try to interview her?
I spent 4 hours one day tracking her down. I found where she lived in New York. I found multiple addresses for her. I found multiple phone numbers. If her address is the same as the one that she was forced to put on her filings in this case, she has been fairly litigious in the past, in state and federal court. I've sought attorneys who have represented her. I was not able to get them. I've mailed her directly at her P.O. box and her home address, and she has never, ever responded to me.
That's brilliant. Her attorneys in other cases are also elusive?
Yes. Well, to be fair, I only gave them about one call each because at some point it's Michelle McGuirk and not Watergate. But I mean, I really, really wanted to speak to her because I wanted to see what the motivation was. And reading her filings in other cases, and actually some of the filings in this, I mean, she's obviously a capable writer. I mean, she can put things together. I mean, she's not an attorney, but she knows her way around the court system, whether it be New York State Court or apparently the federal docket too. in some capacity. I mean, she wasn't very effective in Deflategate, but
very dangerous for pro se litigant to have that kind of knowledge. I mean, they're often the scourge of the court system with multiple serial filings, and she took this case not just from the district court to the Second Circuit, but she made an emergency application to Ruth Bader Ginsburg at the U.S. Supreme Court to stay the Second Circuit's mandate. And I don't know what her end goal was, but had that application been granted, maybe Brady wouldn't have been suspended, which brings me to my next question to you. Are you surprised at the suddenness at which Brady gave up the legal battle? Because he had two more hands to play. He could have filed an application for a stay with the U.S. Supreme Court, and then going beyond that, sought cert review from the U.S. Supreme Court. Were you surprised?
No, because at that point, I think just the certainty of knowing when you will be back and when you will be suspended, I thought that carried some weight, at least in my opinion. He knew he was going to miss the first 4 games, that it wasn't going to be missing playoff games or playoff games in the middle of the season if indeed cert was denied. So I think that he just once he lost, it seemed pretty obvious that he was just going to take it, because if he could be missing a game this Sunday for all we know. If he hadn't done that, and that would be a lot more damaging in the home stretch of the season.
Yeah. I love the move of his when he restructured his contract to move most of his salary into bonuses. So when he was suspended, that he really only lost, a few $100,000 rather than a few $1 million. That was a pretty brilliant move on his part.
Yeah, it's clever maneuvering. I like that too. But yeah, do you guys? So my understanding was, and maybe you guys can educate me on this, is that they were going to move on without him. There was still the idea that his attorneys would move on without him and potentially appeal to the Supreme Court. They didn't necessarily need him. There's still a conflict of law, I presume, in their minds. Isn't there still a chance that this thing can go to the Supreme Court without Tom Brady on board?
Well, not anymore. The deadline for filing a petition for writ with the U.S. Supreme Court came and went at some point in October. But that does beg the question, and it's one that has mystified me as well. Brady could have foregone an attempt to stay his suspension, but that shouldn't have impacted the NFLPA's decision to at least take one more kick at the can. Right? If the NFLPA had filed a petition for writ of certiorari in mid-October and it's denied, as probably would have occurred, that's no skin off Brady's back. I mean, he faced his suspension and he could have lost nothing more. And that kind of a Hail Mary by the NFLPA, I'll use a football expression, even if it had a slight or infinitesimal chance of success, it did keep open the possibility that the Supreme Court could have vacated the Second Circuit's decision, and we'd be looking at a new landscape legally going forward. And I still don't understand why the NFLPA gave up that chip. I know it's Brady's decision ultimately. He's the real party in interest. But the NFLPA was also a party to litigation, and there are hundreds of other players that could be impacted by the Second Circuit's ruling. So I was shocked that the NFLPA, while Brady took his punishment, that the NFLPA didn't try to take it to the final frontier.
Yeah, I agree that I was surprised by that. And just so how it looks, procedurally, the NFLPA can just continue on and it would be a pure legal question, whereas, even if Tom Brady gave up the case, he could serve the suspension. I don't believe that would moot the case, although there was sort of an argument out there that may happen and the NFLPA couldn't have continued the case. But sort of the other...
He's still got the money. He's got the money that he's lost. So,
right.
That's still an aggrieved injury or an aggrieved, position.
Right. And there was sort of this other interesting dynamic happening at the same time, which was the Adrian Peterson case. We were waiting on the Adrian Peterson decision from a different federal appellate court. And if that decision had gone the other way, there would be what's called a split in the circuits, and from there that makes the case up to the Supreme Court much more likely, because it says 2 federal appellate courts are disagreeing, we need you to come in and settle this disagreement. And that's usually the type of cases that the Supreme Court takes, although it still would have been a long shot. It would have been more likely at that point. But as we know, the Peterson case, Peterson also lost that. So there wasn't a split. And I guess my only explanation for the NFLPA not continuing it was just such a lost cause that it would just be essentially a waste of money to put together the petition to the Supreme Court. I can't really think of any other reason not to.
Yeah, well, there's always the First Circuit or the Ninth Circuit. Bob, do you ever think back to why Brady didn't try to file in Boston instead of Minnesota? We know that the NFL jumped the gun and filed their case in the Southern District of New York, but the Players Association responded pretty swiftly and selected Minnesota as a forum. Do you ever wonder why Boston wouldn't have been the likely, hometown venue? I think if you're looking at, trying to get home cooking, the best chances for success, I would think Brady filing in federal court in Boston would have been a great shot across the bow, and you're talking about a true home court advantage. What was their thinking in selecting? We know why they selected Minnesota, all of the prior precedent, but to me, Boston would have been an obvious venue choice.
I mean, it seems like it was just the Judge Doty factor, if I remember correctly, that if they could somehow get into his court, that they stood a great chance of winning. I guess the question never came up. I never thought to ask them why they didn't file in Boston. I guess it could have given them definitely a home field advantage, but. I don't. Does that play really in federal courts? Like, I frankly haven't practiced in the federal courts. I know in state courts there's always the concern you're going to get some home cooking from the judges, but I'm not sure. Does that kind of pan over to the federal side?
Well, there is. I'll give you a quick personal story, and it's a Tom Brady story, actually. I got dished, or I got served home cooking in the Southern District of Florida before a federal judge. And one of my opponents at a status conference, no less, tried to ask for relief that was not part of the scope of the status conference. And I was objecting. I go, Your Honor, this is not, presented to the court. They're trying to, argue future issues that have not yet occurred. And, the judge said to me in ruling against me, there are a lot of things that I would like in life, Mr. Wallach. I would like to be married to Tom Brady. But I know I'm not going to be, and just like the same, you're not going to get what you want. And the reason I bring this up, and I won't name the judge, but there was the hint of a relationship, a professional relationship between the judge and my opponent. My opponent had a great deal to say about her getting appointed, her or him, to the federal bench, and it happens in state court or federal court, whether it's an elected judge, an Article III judge, a governor-appointed judge. They're all human beings, and I believe that there is a degree, at least in some instances, of home cooking, and a dispute like Deflategate being litigated in a Boston federal court. I think that would have been in the air, and could have resulted in a different outcome. But the lawyers made a strategic choice to roll the dice and hope that they would get David Doty. There's no guarantee that they would have ever gotten him, and they did not get him. David Doty is not the reflexive default choice for every NFL controversy. He's gotten most of them, but as we've seen in the past, Susan Nelson in Minnesota has been assigned cases. And if I were to criticize one decision, it was the election of the PA not to file in Boston. I think that could have been a significant difference or difference maker, because maybe the Boston judge does not kick the case back to New York. Yeah, the principle in federal court is this first filed rule. Whichever case gets filed first rests jurisdiction. But there are also exceptions to that, and one of the exceptions is a fraudulent or preemptive filing. And I think the facts were pretty clear here that the NFL engaged in some kind of underhanded conduct in wresting the forum choice away from an appellant. It's the appellant that has the forum choice, not the respondent, not the appellee, and that's the opposite of what took place here.
That was the fun part of covering this, by the way. One of the fun parts of covering this is that to the three of us and to other people in the legal realm, you look at that move by the NFL and you go, wow, that is shady. That's you kind of did you had like a page boy outside the court just to make sure you claimed jurisdiction. But the average reader doesn't know what that even means. They don't know what this jurisdictional thing means, why jurisdiction matters, how jurisdiction occurs. So trying to explain it to them in terms that I think resonate, that it is sort of like race to court, and did everything they could to make sure it is in their own backyard. That was part of what I enjoyed about covering this, is kind of explaining this to people who understand what a zone read is, but may not understand what personal jurisdiction is.
Yeah, it was a fascinating case in that it elevated discussion on so many issues that are foreign to lay people. And it made cases strange to even lawyers. The law surrounding judicial confirmation of arbitration awards, that's pretty in the weeds, even for most practitioners, especially non-litigators. But for litigators who don't practice in the arbitration setting, this case was like going to school on so many areas of the law: civil procedure, appeals, personal jurisdiction, venue, arbitration, standards of review. And one of the great things about getting into sports law as a commentator is I feel like I've learned more in the last 2 or 3 years than I ever have practicing cases, because when you practice, you're pretty much in a specific zone of subject matter, and you try to specialize where you can, but sports law, it comes at you fast and furious, and whether it's Aaron Hernandez criminal, case law or Deflategate, it is just this incredible advanced, like, master's education in law.
Yeah, I agree. And for me, Dan Wallach is an appellate lawyer, so I think that stuff comes very natural to him. For me, I've handled a few appeals, but it's not my bread and butter. So going through that whole process, I learned a ton about the en banc process here, and also in the sports betting cases. I've learned, and now I feel like I'm an expert on how that all works, and even talking about how things get petitioned to the Supreme Court. So it was cool, and I think part of the coolest, one of the best parts for me, on my website of writing about this, and I take probably a more legal approach than you're forced not to, Bob, because you have a more mainstream audience. Was hearing the feedback that people were learning a little bit more about the legal process, and I think that's something that everyone should know about. And I think cases like this make it fun enough for people to learn about these sort of things, and so that's almost the most beneficial part of this whole thing from our perspective.
Yeah, for example, there's a person who sent me an email asking, is Tom Brady going to go to jail? I explained that no, that Mr. Brady will be fine, and at worst he misses 4 games. And then I tried to, in a few paragraphs, just in an email, explain the difference between criminal and civil matters. And so, at the very least, there's one person out there that got a little bit of an education out of this thing.
Yeah, and I think law school applications to schools in the Boston area are going to be up on the up on the rise. I mean, think of how captivated millions in the New England area were by this case. I would have to think that this controversy and the sense of outrage that people feel may have spurred a rise in law school applications. Have you heard of any instances where someone has made a definitive career choice and said, I want to become a lawyer because of just the injustice that they experienced in this matter, or the outrage that they feel?
I actually spoke at a Suffolk Law School class about Deflategate. And the professor told me it was one of the more well-attended classes he's had, and he teaches sports law over there. And so people showed up and they were interested, and they had some good questions, some of which I didn't have answers to because I don't know if anyone does. But it was interesting explaining this to young future lawyers. One thing I just want to bring up here, and this is sort of, maybe it was just insular here to the Boston area, but sports radio commentators, sports writers, giving attorneys like that have been watching this case a hard time for getting things wrong. Say for being like, all the attorneys said that he had no chance in front of Judge Berman. All the attorneys, they said they had no chance, that he was going to win in front of the Court of Appeals. I mean, these guys don't know anything, yada, yada. What hypocrisy. These guys pick games every weekend, and they get it wrong. And this is the law. I mean, this is even more difficult to pick than that. And it was one of those things where I watched it and I was like, you know what? If you don't want to listen to what the attorneys have to say, then guess. Because your guess, frankly, is as good as anybody else's. And what we're doing is we're applying the facts to what we know to try to make an educated opinion. If you want us to say it's 50-50 every single time, no one's going to read us. So
I went pretty in deep on the Brady side, so I didn't feel any sense of criticism from any quarter in Boston. I think early on when I read the transcript of the first or second court hearing before Judge Berman, it seemed pretty obvious to me that Berman had issues with so many of the NFL's positions that I had this epiphany that there was absolutely very little chance that Brady wasn't going to win, and I called it as such. So I got the other side of that. My profile and the respect for my opinions was elevated in Boston because I chose to cast my lot with the Brady side of the law, and I turned out to be right in the lower court. And in an area where there's just so much passion, people aren't going to see things neutrally. They're going to like or give more attention to the voices that reinforce what they believe. And in Deflategate, at least in the lower court opinion, I thought Brady was going to win, and the attention that I got in Boston was commensurate with that. Had I said that Brady was going to lose, then I would have been on the other side of the perception, and I would have been criticized as someone who doesn't know what he's talking about. So it's just like with politics.
Have you guys been asked the question, do you think he did it? I've been asked that question many, many times by people. I remember similar to, not exactly similar, but during the Aaron Hernandez trial, people would ask me, do you think he did it? And you can't say anything. I mean, what do as a reporter, as an attorney, you can't just throw out whether you think someone's guilty or not guilty. Did you guys get that question about Tom Brady throughout this process? Do you did they ask, did he do it?
Yeah, I think every day, or every day it was in the news at least. I think that's what people want to know. They want to come to you and they want your prediction, and they want, oh, did he do it? Like we were, some kind of fortune teller, and that's just not true. And for me, it was like more fascinating to focus on the legal issues and those sort of things, which is sort of out of line with what the layman just wants to get to the end point. But definitely get a lot of that. In other cases, we get that all the time as well, and whether he's guilty or not. And the thing about this case, which kind of going back to our last question, was the interesting thing for me was that the support was so one-sided in this case. I mean, pretty much nobody out there, unless you just hated the Patriots because you liked the rival team, was cheering for Roger Goodell in the NFL. So it was certainly difficult to take a position against the Patriots, even if you thought it was right, because you knew you were going to draw all this criticism back to you. But at the same time, that when you think it's true, you have to do it. So, but I was kind of in Dan's boat as well, as pretty much being pro-Patriots and pro-Brady the whole way, just because of how things happen.
Yeah, I mean, I don't get asked that question a lot. Did he do it? But I will say this: quarterback of all the positions on the team, I think a quarterback is more of a control freak about all elements of his game and what affect his performance than any other player in that locker room. And did he do it? What did he do? I would have to think that Tom Brady is precisely aware, not just generally aware, of what the weight of his football should be. And does that mean he did it? It was irrelevant. By the time I got involved in looking at this case and trying to rationally think about it, it wasn't about guilt or innocence. It was about the fairness of the proceeding, the evidentiary rulings that went against him. Did Tom Brady receive a fair day in court? Were the proceedings fundamentally unfair? That was always what I hung my hat on when I opined about it. It was beyond fact finding at that point. It was scope of the punishment fitting the crime. It was a question of hearing, due process, and a sense of proportion as to whether the accused conduct merited a suspension of that magnitude under the terms of the party's contract, the collective bargaining agreement. So, did he do it? Did he not do it? It's besides the point. This case was not about guilt or innocence. But if you ask me if I think he knew of not a scheme, but he's a control freak about all aspects of the football, and it would not be completely a foreign subject to him to know what the weight of the footballs are. He probably demanded it, but does that mean he did it or that he committed some kind of an integrity violation? I don't think so. I think all of the quarterbacks around the league take this view as to wanting the balls to be of a certain weight, and to single out Tom Brady and then not question the NFL, not question the Giants or other teams about ticky-tack violations like that. I think goes to the real heart of the problem, which is this disproportion between the alleged crime and the punishment, and of course the process and the hearing that was afforded the accused. That's where the real issues lie in the case, not guilt or innocence.
Yeah, that was for me like one of the hardest parts about sort of being involved in it and trying to explain to people that it's not about whether he did it or not. Nobody really knows whether he did it or not other than him and maybe the ball boys, and we're not going to find that out. Really what this is about is the process at this point, and whether or not the NFL applied a fair suspension and had a fair process in doing so.
Yeah, and it's also whether or not he did it seems immaterial. It's whether or not, and this goes for all cases that I cover, it's whether or not the charging body proved that that person did it. They could have done it in broad daylight, but if you can't prove that that person did it, then it doesn't matter. And I think that that's something I try to get across to people, because that is the reason why we have courts. That's why we have rules of law, is to make sure the charging bodies are held to some standard, above our own.
Yeah, and the difference in this case is that there was no accountability. The charging body in this case, whether or not it proved its charges, it got to decide whether it proved its charges. So unlike a court of law or a state court judge or a federal court judge, where you have varying standards of review, a de novo review, the NFL in this case was in a quite different posture, because it got to decide guilt or innocence. It got to decide punishment, and more importantly, decided on the substance of the appeal. So by the time Tom Brady entered the court system, he was already DOA, given the extreme deference that courts give to arbitration decisions. And this wasn't really like a true arbitration. This was like a disciplinary proceeding. Plus, Brady never got the benefit of a de novo standard of review or an unbiased fact finder. So at each level up that he went, to the arbitration appeal and then to the district court and then the appellate court proceeding, the standard of review was stacked heavily against him, and he had to run that gauntlet and not just win, 1 out of 3. He had to win the last one, most importantly. And to this day, the final score is going to be NFL 1, Brady 0. But it's not quite like that because of the difficulty of overturning an NFL disciplinary charge.
So I got a question for you guys. This is kind of a hypothetical that I've put towards people, and I'll do the same with you here. Like, let's use the Giants, for example. If Eli Manning is generally aware that another player on his team is taking steroids, under the powers that Roger Goodell has, can he be suspended? Can he be suspended for 4 games? Or is that not exactly a good parallel?
Well, it's different because it doesn't impact how well that Manning could play the game, because it's not him directly, it's not him throwing the footballs. Would be my argument, but my argument would also be that Goodell does have the power to suspend him under that. Power's just so sweeping right now. There's really, if you take a close look at the Second Circuit opinion, you'll see that he doesn't need to explain his opinions well. He can basically just railroad them and call it a suspension under his section Article 46 powers, conduct detrimental, the name of our podcast, and go from there. And pretty much he can do whatever we want. Dan, what do you think?
Well, at some point, the NFL's winning streak will run out. Remember, at this point a year ago, we were musing over how the NFL kept losing each and every time it ended up before a neutral fact finder. You know, whether it was Barbara Jones in the Ray Rice case, or the Bountygate decision before Paul Tagliabue, and of course. Yeah, so the NFL was like, lost 6 in a row. Now the NFL has won 2 cases in a row, and at some point your luck runs out. There's a swinging pendulum of justice, and if the NFL tried a ham-handed maneuver, such as suspending a player for being generally aware of another player's steroid use, that fact pattern would be so absurd to lead to a result that favors the NFL that I think it would end up in court. And the NFL could conceivably see a new federal appellate opinion curtailing the commissioner's powers, or at least chipping away at the Second Circuit's precedent in Deflategate. So you got to tread carefully here. I think the NFL should take put its win in its pocket, and selectively use it where the circumstances and facts warrant it. Should the NFL go overboard and overreach in its disciplinary powers, I think its win, or at least the precedent of Deflategate, could be short-lived if it uses that power in a way that is completely illogical and flies in the face of law.
I think we all can agree that this case that we're talking about was an illogical use of power on behalf of Roger Goodell, and he still won. And the fact is, not only did he win, but now he has 2 federal appellate decisions in his favor that are going to be binding, or the best precedent over these other decisions they've lost moving forward. And so I think until something's collectively bargained to change how this system works, that the NFL for the next 3 or 4 years can do basically whatever they want.
Yeah. And not going to be helped by a Donald Trump presidency with the appointment of judges that would tend to espouse conservative judicial philosophies. So over the course of time, the balance or the mix within the federal courts over the next 4 years, or God forbid 8 years, will probably skew more towards upholding that kind of Second Circuit and Eighth Circuit precedent, rather than reshuffling the deck and maybe having a different panel take a fresher look at Deflategate or Peterson in a future case. So I think, taking the longer view, this is not going to get any easier for the players.
Donald Trump, Deflategate, really the stories of 2016, I would say.
Yeah. So along those lines, I mean, we're looking ahead. We're seeing, the NFL CBA expires in, I think, 2021. So we have 4 years more under this current CBA. When negotiations come back up, I mean, has Deflategate and some of these other cases that we've seen where players appear to be, railroaded or treated poorly, or just kind of exposed the current arbitration system of Goodell giving out the suspension and then sitting as the arbiter over his own decision, and sort of the inherent unfairness in that process? Has these cases shown enough to you guys to really make this a priority for the NFLPA in negotiations in the next CBA, to the point where they would be willing to lock out if Goodell doesn't give up some of his power?
I mean, I would assume so. It has to be. I mean, it directly affects the players. It directly could potentially affect any single player in the league. And so what's the union there for, is to protect them. I assume now that you have binding precedent in 2 different circuits that the NFL is coming from a point of strength when it comes to negotiations. So you have to assume players have to give something up if they want the NFL to do the same. Whether that means more games, whether that means more preseason, or whatever. If whatever it's going to be, I guarantee it puts more money in the NFL's pocket, not less. So it's I assume the NFL is coming from a position of power. The players are going to have to try to take some of it back, but it's going to cost them. I have to guess it's going to cost them.
Yeah, I'm more of a cynic, and the players are signing these very lucrative deals. By way of example, Janoris Jenkins, who's playing wonderfully for the New York Giants. Bob's a Giant fan, so am I. He's probably earned every penny of it, but he just signed a free agent contract that pays him $16 million annually. And going forward, those numbers are going to keep going up and up and up. And I'm not convinced, and I'm skeptical that a body of players that don't play for very long, the shelf life of a National Football League player on average is less than 5 years. I don't see the players striking or maintaining their solidarity over who gets to decide disciplinary appeals in just a handful of cases, when the bigger issue for the players is the piece of the pie that they get, and ensuring that they can continue earning those kinds of contracts. Because sitting out a full year while an antitrust case is pending is not an option for players that have an average playing career of less than 5 years. So at some point, it's a leverage play for the NFL to give some of that up in exchange for maintaining either the current allocation between the players and the owners on revenues, or paring it back, or having it only go up just a little bit. So the owners hold all of the cards here, and the players will never be in a position, millionaires fighting against billionaires. It's a losing battle every time, and this issue does not rise to the level of being one to sit out a season for. Yeah. So at some point, it becomes a quid pro quo for something.
I think if you take a closer look at the negotiation dynamics of this situation, where I think the players recognize that it's unfair, but I also think that not a single player out there thinks that it's going to affect them, right? So I'm sure Tom Brady was in that position. He was like, well, I worry about my fellow players, but I don't think I'm going to be in the position where this discipline process is going to impact me before it, like it obviously. And so at the end of the day, when they're coming down to, well, do we have to give up a piece of the pie, more guaranteed contracts, something that's very important to the players, something with health, 18-game schedule. Is that what we're going to give up for something that impacts 2 to 3 players, maybe 4 players a year? And at the end of the day, when they're voting on that, it's just an issue that's probably going to get passed over again. And I'll guarantee you that the NFL is going to take an extremely hard line on this issue. Goodell's been on the record multiple times saying that one of the most important things to him is, quote-unquote, integrity of the game. And he views integrity of the game as his ability to control the judicial system, and if he doesn't have the appeal power or the power to sit over the appeals, he doesn't think that he has control, the ability to control the integrity of the game. And I think that's something that I just don't see him giving up. I think since he's been elected, he's had all those sound bites, and it'll be interesting to see. I'm intrigued.
It's getting out of hand, though. I mean, every day brings new announcements of fines, suspensions. If you compare the Roger Goodell NFL versus the Paul Tagliabue NFL or the Pete Rozelle NFL, it's like night and day. And the more he does this, I think it drives a wedge between the league and its players. And if there were ever going to be, and I know I just said it's not worth sitting out over, but if there was ever going to be a battle, a real, a battle for control here and something worth striking over, I think Goodell has been such an extremist in how he's applied the rules against players and suspended them that they're never going to be as unified as they are now in their utter hatred of Goodell and the way that the system probably is. So I think a smart move for the NFL would be to, let Goodell ride into the sunset before the next round of CBA negotiations comes along, because he's a rallying point. He's a rallying point not only for the players, but for the media now and the court of public opinion. And the NFL had a significant PR advantage during the 2007 lockout. I don't think it was a 2011 lockout. I don't think the 2021 lockout will see anywhere near the same kind of sympathy and support for the NFL's position vis-a-vis the players. Not when owners are picking up and leaving cities and showing such disloyalty to markets like San Diego and Oakland and you're reading about what the franchises are selling for, I think public opinion and the opinion in the press has been crystallized heavily against what the NFL has been engaged in recently. And if the players were going to have a perfect storm for success, at least if not in the courtroom, at least in the PR battle, I think 2020-21 is shaping up to be a very strong situation for the players if they marshal the unity and can stay together, but ultimately they don't have the upper hand here, at least with the negotiations and at least with the leverage of sitting out a game or sitting out a year when the owners could easily forego a year's worth of revenues because they're billionaires anyway. So I think it's going to be a big battle in 2021, but I just don't see the players having the staying power, although the stars are aligning for the battle to end all battles here if Goodell is still at the helm.
Yeah, but you also, they have to keep an eye on television revenues and see. There's a lot of time between now and 2021, and you see there's the early season television revenues going down. Goodell's job is to make sure that the owners make money. I think if you had to boil down what his job description is, if the league starts losing money, I think that is a situation where all of a sudden, who knows who? I don't know if the players get more leverage, but there's more leverage to go around if all of a sudden the bottom line starts dropping out. That's something to be seen in the future. But you can almost you can kind of tell that the railroad momentum that the NFL is starting to slow at least a little bit. It's not just Jesus take the wheel, this thing's never going to end. It's starting to slow a little bit, and if it slows too much, then Goodell himself could be in trouble.
Yeah, I think that's a great point. And if you look at the past two NBA negotiations, I think that's very instructive. So this most recent one, they just agreed to one the last week. The NBA is in a great financial position. They didn't want to screw it up. As opposed to the one before that, they were in a tough financial position. Owners were claiming that they were losing money. It caused a labor dispute, a shortened season. And I think at the end of the day, if the money's coming in, both sides are going to find a way to come to an agreement. These other issues are sort of ancillary. But if it's not, if there's really going to be financial issues and we see the ratings drop, and I think your point, if they're not making more, even if they're still making money, but it's just less than they had been, we could see a situation where, we're in for a big change. And obviously the TV market and the TV revenues is a moving number at this point with ESPN losing 500,000 subscribers every month. There's been some talk of, I read an article about how Disney, the author thought Disney should spin off ESPN because it's a sinking anchor at this point, and I don't necessarily agree with that. I think there's new ways to create revenue, but it's definitely, I think to Bob's point, we have a few years away, and there's going to be a lot of changes between now and then.
Yeah, agreed. But I do expect someone other than Roger Goodell to be leading those negotiations in 2021. It is a long time away. You really?
Yeah.
Okay.
He's making so much money. He's making the owners so much money still. He is literally their shield against everything. He's shown a willingness to take all the criticism and basically get paid for it. So I unless he voluntarily steps down, which I also don't see happening, and he's young enough where I don't think that's an issue before the CBA. I don't see it happening. Not to say that it would be a bad move. I think it would be a good move, but the dynamics of it, I disagree that it'll happen before then.
Yeah, I just think his insertion in the process would create a dynamic and would create a sideshow and embolden the players to stick to their guns on their unity and fighting for what they want in terms of eliminating the current disciplinary system or at least changing it. And if the NFL were to have a different point person, it might make for smoother negotiations. Michelle Roberts and Adam Silver are proof positive how a positive working relationship can eliminate all the collateral issues and focus not on the personalities but in trying to get a deal done. And I believe Goodell's personality combined with Kessler's, because Kessler will be part of this, could be a toxic combination.
I tell you, there won't be many tears shed in the New England area if Mr. Goodell steps down. I think it'll be a day for celebration around these parts.
Yeah.
Yeah. Hey, great thing about Deflategate. If we're gonna wrap it up and revisit an issue, the one takeaway for me, all the great new people that I met during this long and winding road, which lasted less than 1 year, but I met more people in this case, more new people. I knew Bob, I think, before Deflategate, but Bob's certainly one of the many, and certainly one of the most prominent relationships that were fostered by the Deflategate case. And I don't think I'll see another one like this that crosses over so many boundaries of sports, media, and law that exposed both Dan and I to so many cool new people. Bob, did you have the same experience in your relationships and meeting different folks across so many divides?
Yeah, that's one of the reasons why I was actually kind of happy that the NFL got the case in New York, because if it was in my backyard, it would have been a lot of the same crowd that I meet and talk to every day. But it was good to get to New York, meet a lot of the guys, meet a lot of attorneys, a lot of good reporters. And it really was an interesting cross section. I mean, you have sports reporters, rubbing shoulders with news guys who were talking to attorneys, and it was really and it was a circus. I mean, come on. To get out of court, we had to run down the stairs. I had some guy outside holding my phone so I could just quickly start tweeting, and it was it was awesome.
That was ridiculous. That was kind of an archaic rule. I remember you and I experienced that circus together for the Second Circuit oral argument. We couldn't bring our phones into the court. We were shepherded into a holding area that was almost like it was like an Al Qaeda trial where they would only take 4 people at a time, groups of 8, and move them into the courtroom. I had to take your phone. Remember, we found a holding place for your cell phone in the Fox News truck, and it was just such a weird thing to actually have to have all of these barriers imposed upon us. But it was all worth it. I mean, all those hours of waiting, the line. I'll never forget the day that we were in this holding area that also held Paul Clement, Jeffrey Kessler. I'm looking at recognizable folks from NFL, from the news networks, from ESPN. For a lawyer that had never been in any kind of a public setting like that, maybe a couple, but nothing quite like that. It just blew my mind, and I made so many good friends from it. I was sorry to see the case end, if only because the relationships that were developed would kind of like slow down and not be as frequent and recurring. I know you and I are going to probably talk about a number of things going forward in our careers as new stories develop, and I'll always pick up the phone and want to call you. But that was the best part of Deflategate, just the cool new relationships that Dan and I and you formed, crossing over so many divides like that. Sports, news, media, law. It was fun. It was. Well, we'll always have daily fantasy sports, right? That'll be around forever. We can always talk about that.
Well, thanks so much, Bob, for taking the time today to discuss the Deflategate with us. It was a blast. You did a great job covering it. Everyone, I would recommend checking Bob out on Twitter at Bob McGovern Jr. Bob, what are you working on these days? What other stories, cases are you following?
Well, we have the Aaron Hernandez's next murder trial coming up here during the winter. There's the case of Michelle Carter. She's the young woman who allegedly coaxed her high school boyfriend to kill himself via text messages. And so it brings up the intersection of criminal law and the First Amendment. And, of course, the day-to-day stuff that kind of shows up in the docket that I'm not expecting, but I'm always excited to see.
Great. Yeah, I was definitely looking forward to hearing more about the Hernandez second trial. It's that's its own crazy case to begin with, obviously, but Patriots have a way of finding themselves in the courtroom, it seems.
Yeah. I know you joked about daily fantasy a moment ago, but there's a federal criminal investigation supposedly going on out of Boston, focusing on some of the activities that took place last year with DraftKings and FanDuel. Have you heard anything about the status of that investigation? Because it's been crickets for the past year. Nothing coming out of the Boston U.S. Attorney's Office.
I had heard rumors about certain things from sources outside of that office, but I haven't been able to substantiate things that I can report. But I have my ear to the ground, and I'll be paying attention. And I'm sure my colleague Kurt Woodward over at our competitors on Morrissey Boulevard is paying too.
Yeah, he's a pretty good one. He's probably standing outside of the U.S. Attorney's Office as we speak. So you're going to have to hustle to scoop him on that story. But you probably have some very good sources that he doesn't. And I don't know what's going to come out of that, but they haven't announced that it's been closed. So I would expect they're just taking their time, and at some point we'll hear something. And you might be the first to report it.
Or first to file, as it were.
Well, thanks again, Bob. Really appreciate it. Have a good rest of your weekend, buddy.
Thanks, guys.
An honor, Bob. Thanks for joining us. Thank you.